Like sit down. All right, when we start taking a look at alternative dispute resolution, that's ADR. ADR is an attempt to try to resolve it outside of trial. As I said, a typical trial will cost between $150,000 to $175,000 for a simple case. You could take a case to arbitration for about $15,000. It's a lot cheaper. And if you can try resolving it in a way where both parties at the end of the hearing can have a working relationship. So you have, for example, let's say a dispute between a professional league and a network. Who's entitled to which game, maybe, to broadcast? Or if they change the timing of a game, or if there's a weather issue. So let's say a game gets postponed, and that TV network is counting on that game for revenue. You think they're automatically going to go and sue the NFL as an example and say, well, we lost the broadcast rights, we lost X number of millions of dollars. They don't want to do that because that will harm that relationship. What they might do is say, look at, you know what? We think we lost $10 million. You think we lost $3 million. Why don't we take this to either a mediator, which is a neutral party which will help us talk it out, figure out a solution, or you might say, let's take it to an arbitrator which can help decide the issue, and then we can move forward with our relationship. Because what you don't want is on either side to create a bad relationship that they're never going to work together again. No, no one wants that. And that's one of the benefits of alternative dispute resolution is how can we resolve it? I mean, it's just like a brother and sister fighting. Think of it that way. You know? You love each other, but at that point, you're pissed off as all hell at what your sibling has done. So what did you do? You ask another brother or sister, or maybe the parents, can you help resolve this for us, kind of thing. That's what ADR is. So you try to reduce cost, it's a lot quicker. You can find creative solutions, oftentimes that a jury will never think about. It could be confidential. That's very important when you have a decision where it might set precedents, let's say like the concussion cases. If the NFL had gone through arbitration and settled a couple of these cases through that process, it could be confidential, no one will ever know about it. That's why oftentimes when you have a decision that's reached through arbitration or through settlement, what they often say is that it was a private decision, it was confidential, so that we cannot say what it is, but the case is resolved. And that's often done that way so there's no precedence and no one else will know what happens, so it limits future lawsuits. Also could be increased satisfaction on both sides. You know, hey, this is great, we're able to resolve this. On the other hand, it can be harder to enforce. Because instead of having something that's from a judge, it's from a third party. And even though it might be a contract that everyone signed, people lie in contracts, people lie in front of courts. So you might have a situation where you thought you got it resolved, and then the other side, which was supposed to pay you money, is they're not paying you. What do you do? So now you have to go back and say, we need to enforce this, so you have to bring it to a judge to enforce that decision, and the judge might say, well, I don't think that the arbitration was accurate, I don't think it's appropriate, I want us to retry this from the very beginning. Then all your time and energy is wasted. That's why oftentimes you have a clause in a contract, like an employment contract, but this is final and binding resolution is what you're looking for. And that if anyone brings it to any court, the losing party has to pay all attorney fees, all expenses, and double of any actual damages. So you try putting in there a clause that will punish someone if they try to fight an arbitration ruling. And so I encourage people to go and take a look at ADR as a way to help resolve different areas. Now, ADR is also something that we see in the Olympics now. Just imagine if you are, let's say, a sprinter. Click, and you take off from the blocks. The gun hadn't fired, but they clicked it and pulled the trigger. And they say, okay, false start. And they kick you out. What if you want to challenge that? Can you challenge that? And so there is something called arbitration to sports, which was started by the Olympic movement a number of years ago which is designed to resolve issues right there during the Olympic Games. Because there are issues. Remember a couple, just back in the Salt Lake City Olympic Games, where they had the French ice dancers and the Russian, and the French were given a better score, I think, than the Canadians, because the Russians and the French had agreement, you vote for ours, we'll vote for you kind of thing, and then they got caught and they got busted. You don't want it to go to that far. If there's a problem, how do you handle it? And this is where they handle eligibility issues. You know, are you in fact a citizen? You know, are you in fact male versus female? Those kind of issues, it can be brought through arbitration now, so that the games can continue, so they have like immediate arbitration to resolve something, so that way the games can continue and just doesn't get mired down in constant disputes. Okay.